Florida is known for its sunshine, beaches, and some of the most talked about self-defense laws in the country. From stand your ground to the castle doctrine, the legal landscape can be your shield or your downfall. In this video, we're breaking down the 4 self-defense statutes that define your rights and responsibilities under Florida law. Whether you're a legal professional, gun owner, or just want to understand your rights, this deep dive could make all the difference in a split-second decision. Let's break it down statute by statute right now. Hello everyone, and welcome to the Firearm Firm channel. I'm attorney James Phillips, and today we'll be discussing 4 key statutes that form the backbone of self-defense law in the state of Florida. We're talking about Florida Statute 776.012, 776.013, 776.031, and finally Florida Statute 776.032. These laws outline when force can legally be used, what circumstances justify deadly force, and when individuals are immune from prosecution. Let's unpack each statute, explore what the law says, and what it means for real-life situations. First, let's start with Florida Statute 776.012, which governs the use of force in defense of a person. This is essentially Florida's basic self-defense law, and it applies whether you're inside your home or out in public. Under Florida Statute 776.012 subsection 1, a person is justified in using non-deadly force when they reasonably believe that such force is necessary to defend themselves or another against the imminent use of unlawful force. More importantly, under 776.012 subsection 2, a person is justified in using deadly force, and this is key, if they reasonably believe that such force is necessary to prevent imminent death, great bodily harm, or the imminent commission of a forcible felony. Here's the big takeaway. Unlike some states, Florida does not impose a duty to retreat if the person is not engaged in criminal activity and is in a place they have the right to be. That's where the phrase stand your ground comes into play. Floridians have no legal obligation to retreat before using deadly force if the situation justifies the use of it. So, if you're lawfully walking in a park and someone threatens your life or safety in a way that justifies deadly force, you do not have to attempt to escape or retreat before defending yourself. That's the essence of the statute. Now, one thing to keep in mind when it comes to Florida Statute 776.012, subsection 1 or subsection 2, is that the law not only allows a person to use force, it also allows a person to threaten to use force. So anytime we're talking about using force, whether non-deadly or deadly, keep in mind that instead of using such force, you do have the option to threaten to use force. Now let's talk about Florida Statute 776.013. This is often referred to as the castle doctrine. This law focuses on self-defense inside a dwelling, residence, or occupied vehicle. Before talking about the actual castle doctrine law, I think it's important that we define the 3 castle doctrine locations. Per statute, a dwelling is a building or conveyance of any kind, including any attached porch, whether the building or conveyance is temporary or permanent, mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. A residence is a dwelling in which a person resides either temporarily or permanently or visiting as an invited guest. Finally, the term vehicle means a conveyance of any kind, whether or not motorized, which is designed to transport people or property. Now, pay close attention to what I'm about to say because this is extremely important. For a vehicle to fall under the castle doctrine, it must be occupied by a person. All right, now we know what places the castle doctrine will apply. Let's talk about what the castle doctrine actually does. 776.013 creates a legal presumption that a person had a reasonable fear of imminent death or great bodily harm when using deadly force against someone who has unlawfully and forcefully enters or attempts to enter a dwelling, residence, or occupied vehicle, or if that person in which the force is used against had removed or was attempting to remove another against that person's will from the dwelling, residence, or occupied vehicle. Here's an example. If someone breaks into your home at night and you shoot them, the law is going to presume you acted reasonably. You don't need to prove that you were afraid. The fear is legally presumed itself. But as with most things in the law, there are exceptions. If the person entering the home has a legal right to be there, such as a co-occupant or a lawful resident, or if the person is a law enforcement officer who identifies themselves appropriately, then the presumption of fear does not apply. Furthermore, if the person who entered the home was attempting to remove their child, grandchild, or someone in their lawful guardianship, the presumption also would not apply. Finally, you need to be aware that if you are engaged in criminal activity or using the home to further criminal activity, you will not get the presumptions that your fear was reasonable. So there's 4 exceptions. You need to be aware of them, because if one of those 4 exceptions applies, you are not going to get the benefit of the Castle Doctrine. So the Castle Doctrine not only provides you with the legal presumption that your use of force was reasonable when someone unlawfully and forcefully enters one of the Castle Doctrine locations, but it also gives you the presumption that the person who unlawfully and forcefully made entry did so with the intent to commit an unlawful act involving force or violence. In other words, the law is going to presume that individual that broke in to your home unlawfully and with force, he's not there to borrow a cup of sugar, he's there to do very bad things to you. What's important about 776.013 is that it shifts the burden onto the prosecution. If you were in your home or your car and someone unlawfully forced their way in, the law gives you the benefit of the doubt in using deadly force. If you want to know more about Florida's Castle Doctrine, click on the video link above to watch our video specifically discussing the Castle Doctrine. Moving right along, let's talk about Florida's Statute 776.031, which covers the use of force in defense of property. Subsection 1 allows a person to use non-deadly force to the extent that they reasonably believe such force is necessary to prevent or stop another person's unlawful trespass or criminal interference with real property other than a dwelling or personal property lawfully in his or her possession, or in the possession of another who is a member of his or her immediate family or household, or of a person whose property he or she has a legal duty to protect. Subsection 2, though, deals with deadly force. It says that deadly force is only justified if it's used to prevent the imminent commission of a forcible felony, not merely to protect property itself. That's a critical limitation. You cannot use deadly force solely to defend property like your car, your bicycle, or your garden gnome. However, if the confrontation escalates to the point where your life or someone else's life is in immediate danger, then deadly force may become justified. So if someone is stealing your motorcycle from the backyard, that does not give you the legal right to shoot them. But if you are on that motorcycle and someone uses a gun to try and take your motorcycle, then you might be justified in using deadly force, because that would be the forcible felony of a robbery. Finally, let's talk about one of the most controversial, impactful parts of Florida's self-defense framework, and that's Florida Statute 776.032, which provides immunity from prosecution and civil lawsuits from people who lawfully use force under the 3 prior statutes we just discussed. Here's what the statute says. A person who uses force, even deadly force, as permitted in section 776.012, 776.013, or 776.031 is immune from criminal prosecution and civil liability. That means you can't be arrested, you can't be detained, charged, or sued unless law enforcement has probable cause to believe your use of force was unlawful. This statute has been the subject of major legal battles and policy debates. It essentially gives the defendant in a self-defense case a chance to avoid trial entirely by raising a pretrial immunity motion. If a judge finds that the use of force was justified under Florida law, the case can be dismissed before it ever reaches a jury. That's very powerful. This immunity also extends to civil court, meaning that if you lawfully use force in self-defense, you cannot be sued by the person you injured or the family unless your use of force was found to be unlawful. Now, one thing to keep in mind is this statute does not prevent someone from filing an actual lawsuit against you. It just allows or provides you a mechanism with having that lawsuit dismissed. And if you're successful, you can actually recover your attorney's fees against the party that filed the lawsuit. Now, one thing about this immunity statute to keep in mind is there is a difference in the burden requirement between criminal and civil immunity. In a criminal case, once a prima facie case of self-defense has been raised in the pretrial motion, the burden then shifts to the state to show by clear and convincing evidence that the defensive force was not justified. Now, in a civil case, however, the person asserting the claim of immunity has the burden to show by preponderance of the evidence that they are entitled to the immunity. In other words, that they were justified in their use of force. So let's recap what we've learned today. Florida Statute 776.012 allows for the use of non-deadly force to prevent the imminent use of unlawful force by another. It also allows you to use deadly force when you are facing imminent death or great bodily harm, or when you believe such force is reasonable and necessary to prevent the imminent commission of a forcible felony. And there is no duty to retreat so long as you're not engaged in criminal activity and you're in a place you have the right to be. Florida Statute 776.013, our castle doctrine, gives you powerful protections in a dwelling, residence, or occupied vehicle by presuming that you held a reasonable belief of fear that imminent death or great bodily harm was imminent when someone unlawfully and forcefully enters one of those castle doctrine locations we went over. Florida Statute 776.031 lets you defend your property, but with clear limits on the use of deadly force. Remember, it must be proportional and justified. And finally, Florida Statute 776.032 grants immunity from both prosecution and lawsuits when force is used lawfully. Together, these laws make Florida one of the strongest stand your ground states in the country, but they also carry immense responsibility. Just because the law gives you the right to use force doesn't always mean you should. Every situation is unique, and understanding these laws can mean the difference between justified self-defense and a serious criminal charge. If you found this video to be helpful, don't forget to like and subscribe and hit the notification bell. Also, be sure to leave a comment below if you have any questions about Florida's self-defense laws or any other Second Amendment or self-defense related question. Until next time, stay armed and educated.